All right. Okay. Okay. Take care. All right. So, Mr. Tozier, you're up.
Good morning again. May it please the court. Garrett Tozier from Schutz & Bowen on behalf of appellant Pulte Home Corporation. So in the last appeal, the trial court entered final judgment for Pulte on the association's claims under the 10-year time bar and the 4 trigger events in what I'll call the third sentence in section 95113 subsection 3C. And while it's Pulte's position that this court should affirm that ruling, or at least partially affirm, partially reverse that ruling regarding the late and early townhomes, the trial court erred in applying that same reasoning when entering summary judgment for the subcontractors on Pulte's third-party claims. This court should reverse here because, unlike that appeal, the Pulte's third-party claims were timely filed under the plain language of the 2018 amendment that created the 4th sentence in section 95113C. The association served its pleading on February 19th, 2019, and less than 1 year later, Pulte commences third-party claims on February 7th, 2020. So I don't think there's that much dispute about what happens in if the prior appeal and the knock-on effects here. We've addressed that in issue 2 of our initial brief in this case, and I'll be happy to address any questions about that. But because it's Pulte's position that this court should either affirm or partially affirm in the prior case, I'd like to focus on an independent basis for reversal on the third-party claims as to all 196 of the townhomes. Pulte might not have any damages to pass through if this court affirms in total, or it might not have any damages to pass through on the early 184 townhomes on a partial affirmance. But the subcontractors, they misconstrue our claims too narrowly. It's not just about passing through damages. It's also they are bound by section 20.2 of each subcontractor agreement to defend from Pulte from the association's claims and incur those costs of defense for Pulte. And so they've breached that duty. And that, and I'll explain later, that doesn't violate the purpose of the 2018 amendment. The subcontractor's interpretation of the 2018 amendment is unreasonable because it requires injecting non-existent language into the 2018 amendment. And I see we've lost Judge Case.
Judge Could I think Judge Case may have just disappeared on us.
Would you like me to wait until he returns or continue?
Yeah, I think due process kind of. I'm stopping your clock, Mr. Tozier, and it looks like we've got Judge Case coming up.
No, great.
Did you go take a dip in the pool, Judge Case? Is that?
Welcome back.
Okay, start up again, Mr. Tozier, and that was right at the 2-minute 30-second mark.
Great. So in the first part of the 2018 amendment is clear. There's no qualifier that the pleading the association served must be timely. It simply says that the third-party claims that arise out of the conduct, transaction, or occurrence set out or attempted to be set out in the pleading, the association's pleading. It talks about the conduct, transaction, or occurrence. Those are the facts alleged in the pleading. The pleading is a procedural device. It's not the substantive relief that's extinguished by the 10-year time bar. That's not the language that the Florida legislature chose in that instance for when identifying what triggers Pulte's 1-year window. And the legislature confirmed this by saying it set out or attempted to be set out. It didn't have to be a successful attempt. It could be an untimely attempt, but Pulte's 1-year window for the third-party claims is still triggered. And the context of the entire chapter supports Pulte's position and doesn't provide any context to say that it should be an untimely pleadings don't qualify. That context I've mentioned in the last appeal, I hinted at a little bit, was the first section of chapter 95.011. That says that an action shall be barred and must be begun within the time prescribed within this chapter. So when we compare that to the last clause in the 2018 amendment, the Pulte can commence its action even if such claims would otherwise be time barred. So what this legislature is saying, that even if Pulte's third-party claims would have normally been barred by the 10-year window, that first section 95.011 uses a different start date and a different trigger event. It's not 4 trigger events and 10 years. It's 1 trigger event, the service of a pleading, and 1 year afterwards. So even if Pulte's claims would have otherwise been time barred, that's a reference back to the start of the entire chapter. It's not time barred at all. So it's easy to reconcile our position between the two appeals. We are relying on the third sentence of subsection 3C regarding the association's claims, and we're relying on this 2018 amendment for Pulte's third-party claims. And we're just simply relying on the plain language of the statute. We're not changing any of the words, whether it be from owner to purchaser or from pleading to a timely pleading. We're not injecting any language into the statutory text. So that just simply leaves the subcontractors in the position of relying on the general notion of a statute of repose, which, that general notion is helpful for understanding the concept that instead of looking at accrual for starting the window of time, you're looking instead towards some other event identified by the Florida legislature. But that other event is simply the service of a pleading. It doesn't suggest that because the association's claims were extinguished, and while that we believe that's true, it doesn't mean that it doesn't have any effect on what triggered Pulte's claim to commence its action, because the Florida legislature didn't use any language in the 2018 amendment to indicate otherwise. So it's unambiguous. We think it's unambiguous. It doesn't, there's no need to resort to canons of statutory construction. And it doesn't violate the legislature's purpose, because somebody had, if any part of the association's claims is dismissed or final summary judgment affirmed, somebody had to incur the costs of defending against that action. Nobody, the legislature didn't create a fee shifting provision for untimely commenced actions that may or may not have been time barred. So, all we're doing here is we're just reallocating the cost between the parties pursuant to each's contractual responsibilities. So, the 10-year time bar still has a purpose. It still defends and bars the merits of the action, and we're just asking the subcontractors to defend and carry the costs of securing the final summary judgment on the association's claims. So the harm is, diminished to the subcontractors, even if there aren't any pass-through claims to pass on, any damages to pass on. So, and if this court disagrees in the prior appeal with our positions, we'd still, even if we allow only the 12 late townhome to proceed, we would still ask a reversal in this case on all 196 townhomes. Like I think I may have mentioned earlier, the 184 early townhomes, we still be able to recover our costs of defense. But for the 12 late townhomes, we'd either be able to pass through any damages to the subcontractors, or if on final summary judgment down there on the 12, we'd be later able to recover those defense costs. So unless this court has any questions, I will reserve the rest of my time for rebuttal.
Thanks, Mr. Tozier. Mr. Rowe, you're up.
Thank you, Your Honors. Again, Randall Rowe for Lawson Industries. This appellate action focuses on a very limited issue, which is that if West Park's initial claims are rendered non-existent by the statute of repose, are Pulte's third-party claims similarly rendered obsolete, even in the face of this one-year language. And so, it's important to recognize, and what we touched on earlier in the prior appeal, that a statute of repose eliminates a cause of action at the time the repose window closes. The cause of action is not eliminated at the time a summary judgment ruling comes out finding that the repose period applied. The cause of action is eliminated at the running of the 10 years, and the summary judgment ruling simply memorializes that. Pulte's third-party claims are directly tied to, contingent upon, and reliant upon the existence of plaintiff's primary claims. The way we have to look at this is that on January 9th, 2019, plaintiff's cause of action ceased to exist. Plaintiff did not file or serve anything that was actually real under Florida law, because there were no damages and plaintiffs had no claims existing under Florida law for which Lawson could be held liable. Pulte's third-party claims cannot arise if the plaintiff's claims don't exist. Looking at the statutory language, it does not read in a manner which supports Pulte's argument. It mentions that these third-party claims that arise out of the conduct, transaction, or occurrence set out or attempted to be set out in a pleading. And I want to stop there briefly, because Pulte seems to argue, or at least imply, that the attempted to be set out language Most refer to situations where a plaintiff attempted to bring a suit, but it was barred by the repose period. And there's really no evidence of that. The legislator does not say that in the statute. Under a plain meaning analysis, this refers to when a plaintiff's initial complaint is dismissed without prejudice for failure to include sufficiently, factually detailed matter to state a claim. And all this is saying is that notwithstanding any pleading deficiencies, you will still start the 1-year clock from the date the plaintiff's initial complaint was served, not the date of any amendments to that complaint. I think Pulte and Lawson agree that the phrase such claims relates to Pulte's third-party claims. So the statute really does not say anything about what to do in a situation where the plaintiff's initial claims were time barred, which means you then need to look at the effects of what a repose bar does under the foundational law, which that it eliminates a claim. And so there's no claim for Pulte to relate its third-party claims too. And there are important reasons why this must be true in practice. This relates in part to the subcontractor's expectations as to when they will be sued. After 10 years passes, a contractor can expect not to be sued, and the passage of time creates a problem with retention of documents and memories, and that's partially why the legislature creates time bars. So let's say the plaintiff is not a few months late to sue. Let's say the plaintiff is 20 years late to sue, which is clearly time barred. Is it reasonable then that a general contractor should still be able to maintain claims against its subcontractors regarding that same transaction or occurrence within the very next year, subjecting those subcontractors to claims now 21 years down the road after the improvement was completed, despite the legislature's clear intent to cut off claims well before this? And that can't be the law. That would be absurd. The legislature's stated intent is to protect contractors from stale claims. That includes, of course, subcontractors. It would violate this legislative intent to suddenly allow subcontractors to be back on the hook for very stale claims because a general contractor filed a third-party complaint within 1 year of service of a stale initial complaint. It would violate the legislative purpose to allow merely one general contractor, but not protect a large group of subcontractors related to those same claims. And the purpose of the legislature's enacting the statute was to protect basically general contractors from a very common problem which arose before this provision was enacted. What we would frequently see is a plaintiff would timely file their claim, but they would do so right before the 10-year window expired. It could be a day before the window expired, and then suddenly the general contractor would be scrambling to bring a third-party claim against its subcontractors, and it would not have time to do so. It would be left holding the bag and hanging out to dry. So the legislature enacted.
We lost Judge Case again.
Oh, no problem. I will take a pause.
He's back, at least in part.
He's still on the phone, or?
Can you hear us, Judge Case?
I can.
Okay. Well, okay. All right, Mr. Rowe, you were at about 4 minutes and 30 seconds. So
Thank you, Your Honor.
start back up.
Sounds great. So as I was saying, this was to protect a general contractor from having to scramble to bring third-party claims if they get sued within the repose period, but a mere week, for example, before the repose period expired. That was not fair to the third-party plaintiff, and they would end up having claims which were barred, and that was why this provision was enacted. It was not enacted to protect contractors' claims for defense and indemnity when the initial plaintiff's claims were actually rendered non-existent by a repose bar. And House Bill 875 discusses the underlying intent here. It states that the legislature is amending the statute, quote, to extend the time to file counterclaims, cross-claims, or third-party claims up to 1 year beyond the current statute of limitations or repose. And I know Pulte has argued in his brief that our interpretation that this is just an 11-year window is wrong, but that's exactly what this bill analysis is saying. And Pulte argues in its brief that our reliance on the bill analysis is improper, but there's plenty of case law where the appellate courts rely on these staff analyses. And in fact, Pulte relied on that exact staff analyses in its response to our summary judgment motion on this issue in the lower court. Now, here's something interesting to point out. This statute does not just talk about third-party claims. It talks about counterclaims, cross-claims, and third-party claims that arose out of the conduct, transaction, or occurrence. And so there's a problem with that. If it talks about counterclaims, it provides an extra 1 year for counterclaims under the same language. Does that mean that a plaintiff can bring a cause of action and then get countersued, and then the plaintiff is told that its claim is barred, but it still has to defend against the countersuit? that doesn't seem to make any sense. That seems very lopsided. That's, it's a pretty limited issue we're dealing with, but I do want to turn our attention back to the.
So Mr. Rowe, you are advocating for a construction of the statute because that seems to make sense versus what just the literal interpretation of the words would be.
Well, I think the literal interpretation would be construed to.
You're saying the legislature would not do something or enact an absurd statute. That's what you're saying.
Well, exactly. The legislature can't enact.
So we should read the language of the statute with that in mind.
Yes, it can't be interpreted in a way that creates absurd results or situations like that. It has to be read in a manner which makes sense. I agree. And the only way in which it makes sense here is to essentially create 11 years. Now, when we're talking about the instant case, Pulte's talking about the damages that are being passed through here, and to talk about defense costs. But, what exactly are we fighting over here for? I think Pulte agrees that there isn't any indemnity to pass through with the non-existence of plaintiff's claims. There are no damages to be passed through to Lawson from that Pulte would have owed the plaintiff. But Pulte still argues that we owe it costs of defense per the subcontract language, and that's actually not accurate. The subcontract reads, and I quote, that we will defend claims which may be brought or threatened against indemnities meaning Pulte, but claims is defined with a capital C, and it is defined under the subcontract to mean liability, expenses, claims, judgments, suits, or demands for damages to persons or property. And here's the key language: arising out of, resulting from, or relating to the contractor's performance of the work. Contractor meaning Lawson. Well, it can never be proven that plaintiff's claims arise, result, or relate to Lawson's performance of the work because, again, plaintiff's claims are non-existent. And Pulte has, in fact, explicitly denied that defects exist at the West Park community in its own pleading, which means it can never be proven that Lawson's work relates to the claims with a capital C. So there really are no damages at issue here to be fought over. There's no indemnity and there's no defense, which is another reason why Pulte's interpretation of this one-year enactment, it leads to an absurd result when there are no damages to be even discussed. The legislature cannot have intended this one-year provision to mean that third-party claims will survive when the initial plaintiff's complaint is barred, because there will never be any damages to pass through. So, like I said, this is a limited issue. I've gone for almost 9 minutes now, and appellant went for about the same amount of time, but there's not really much more to discuss on this issue. So unless the court has any further questions, I would ask that the court affirm the trial court's ruling in this case. Thank you.
Okay. Thank you, Mr. Rowe. Mr. Tozier?
Yes, thank you, Your Honor. I think you appropriately observed earlier that they're not relying on the text of the statute, and instead relying on just general notions of statutory construction that we shouldn't reach if the text of the statute is plain and unambiguous. You can't rely on legislative history as straight out the door. So that might be a secondary consideration if there is an ambiguity, although some more recent courts, we've kind of cited examples in the briefs that, since the summary judgment filings that have cast doubt on the reliability of those. But to the extent that this court would want to, it's only if you determine that first that there's an ambiguity. Same thing with the invocation of what sounded like the absurdity doctrine. That's only used to correct like technical items that are missing, and only after there's an ambiguity reached. We've cited plenty of case law in our briefing regarding the extent to which the absurdity doctrine can apply, and it can't apply when there are reasonable interpretations consistent with our position. That's only pure speculation. That the only purpose for this amendment was to the situation where the association files a complaint on year 9, day 364. There's no context in the statute that says that that's the only purpose for passing this this amendment. And I believe our position is reasonable. If they think that under the contract itself, section 20.2 doesn't apply, that might be a defense, which we will litigate at the trial court. But if it's not a reason to support a bar of timeliness for initiating the action. And I think the other more relevant provision is section 20.4, saying that our duty to defense and all these provisions in section 20 survive until entry of the judgment. So regardless of whether the claims that the association have are barred, we still have the opportunity to recover those defense costs. So regarding counterclaims, that would just be the risk that a plaintiff would run by running afoul of the statutory time bar. If theirs is filed and it's untimely, that's simply a risk that's run by running afoul of a statutory time bar. But again, it's not a situation that's relevant here because we're dealing with third-party claims, and the whole notion that the pleading ceased to exist, it only ceased. It didn't cease to exist. We're still served with a pleading. It's not like courts sua sponte screen for repose periods and dismiss them. At the clerk's office, we would have had a default judgment entered against us if we didn't show up and defend these claims. So there's no other relevant context, I think, to support the position that the association's claim must be timely filed. So unless this court has any other questions, we respectfully request a reversal on all 196 third-party claims. We'd be afforded the opportunity to recover cost of defense for either all 196 or 184, and only pass through the damages for hopefully none, but at most we would think 12 of the late townhomes. Thank you.
Okay, thank you both very much.
You all.
Interesting cases. All right, to leave our virtual courtroom, click this button on the Zoom screen that is entitled Leave.
Thank you.
Thank you, Mr. Rowe. All right, and our next